Before we begin, a quick and important disclaimer. The content provided in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or real estate advice. Real estate laws and divorce statutes vary significantly by state and jurisdiction. The information shared here is based on historical trends and case studies, and should not be used as a substitute for the counsel of a licensed attorney, a certified financial planner, or a qualified real estate professional in your specific area. Viewers are strongly encouraged to conduct their own due diligence and seek expert guidance before making any decisions regarding marital assets, property sales, or legal settlements. In the next 60 minutes, we are going to pull back the curtain on one of the most misunderstood and high-stakes professions in the United States economy: the divorce real estate agent. Right now, as you watch this, there is approximately $30 trillion in residential equity held by American households. For many couples, the family home represents 70 to 80% of their total net worth. When a marriage dissolves, that massive asset doesn't just get sold, it becomes a battlefield. We are currently seeing a historical phenomenon where the intersection of high interest rates, low housing inventory, and shifting domestic laws has made the role of the real estate agent more like a high-stakes negotiator or a court-appointed referee than a traditional salesperson. In the past century, we have moved from a society where divorce was a rare legal scandal to one where it is a standard financial restructuring of a family unit. If you are a homeowner, a real estate professional, or someone navigating the complexities of a domestic transition in 2026, understanding this evolution is not just an academic exercise. It is a financial necessity. The traditional methods of selling a home no longer apply when the two decision-makers are no longer on speaking terms, and today we are going to explore exactly how we got here and how the modern divorce real estate expert survives the fire. To understand the current state of divorce real estate, we have to look at the massive shift in the legal landscape that occurred over the last 100 years. In the early 20th century, divorce was largely fault-based. This meant that in order to dissolve a marriage and sell the marital home, one party had to prove wrongdoing, such as adultery or abandonment. From a real estate perspective, this created a binary outcome. The innocent party was often awarded the house as a form of restitution, while the guilty party was effectively forced out. The real estate agent's role back then was simple. They were an order taker for whoever won the legal battle. There was no need for neutrality, because the law had already picked a side. However, the 1970s brought the no-fault revolution, starting in California and sweeping across the nation. This shifted the focus from who did what to how do we split the assets. Suddenly, the real estate agent was thrust into a much more complicated position. They weren't just representing a seller. They were representing two people with competing interests, differing timelines, and often deep-seated resentment. This era gave birth to the concept of community property and equitable distribution. In community property states, assets acquired during the marriage are generally split 50-50. In equitable distribution states, the split must be fair, which doesn't always mean equal. For an agent, this meant that every dollar in the sale price had to be scrutinized. A mistake in the listing price or a failure to disclose a repair didn't just lead to a lost sale. It could lead to a contempt of court charge or a multi-year delay in a legal settlement. By the time we hit the 1990s and early 2000s, the financial architecture of the American home became increasingly complex. We saw the rise of the home equity line of credit, or HELOC. Before this, people generally had a single mortgage. Now, couples were using their homes as personal ATMs, layering second and third liens on the property. When a divorce occurred, the real estate agent had to become a forensic analyst. It was no longer a matter of sale price minus mortgage equals profit. It became a complex calculation of sale price minus first mortgage, minus HELOC, minus tax liens, minus deferred maintenance, divided by 2, adjusted for separate property contributions. This is where many traditional agents began to fail. They were trained to sell the dream of a home, but they weren't trained to navigate the nightmare of a negative equity divorce. Case studies from the 2008 housing crisis highlight this shift perfectly. During that period, thousands of divorcing couples found themselves underwater, meaning they owed more on the house than it was worth. The divorce real estate agent had to navigate short sales while also managing the emotional fallout of a couple who had to pay money out of pocket just to stop being married to each other. Historical trends from that era show that agents who lack specialized training in divorce often saw their listings expire or end in foreclosure because they couldn't get both spouses to agree on a bank-mandated price. Fast forward to 2026, And the challenges have mutated again. We are currently dealing with what economists call the locked-in effect. Many couples who are divorcing today purchased or refinanced their homes in 2020 or 2021, when interest rates were at historic lows, often around 3%. Now, as they look to sell the marital home and buy two separate residences, they are facing rates that are significantly higher. This creates a massive financial disincentive to sell. The real estate agent is now tasked with helping a couple decide if they should bird nest, where the children stay in the house and the parents rotate in and out, or if one spouse should try to assume the existing low-interest mortgage. These are not standard real estate tasks. These are high-level financial consultations that require an understanding of the Garn-St-Germain Act and modern lending guidelines. The modern divorce real estate agent must also be a master of the 3 Ps: property, people, and paperwork. Regarding the property, the agent must be able to spot spite damage. In high-conflict divorces, it is not uncommon for one spouse to neglect or even intentionally damage the property to lower its value if they feel the other spouse is going to benefit more from the sale. A specialized agent knows how to conduct a pre-listing inspection that is shared with both attorneys to create a baseline of the home's condition. This protects the value of the asset for both parties. Regarding the people, the agent must practice radical neutrality. In a standard sale, the agent is an advocate for the sellers as a unit. In a divorce sale, the agent is an advocate for the equity. They must ensure that all communication is transparent. If they speak to one spouse, they must immediately update the other. They often use specialized software to track all interactions, so there is a paper trail for the court. This prevents one spouse from claiming that the agent is colluding with the other. Regarding the paperwork, the agent must be intimately familiar with the listing agreement and the purchase agreement as they relate to court orders. They need to know if there is a Rule 706 appointment, which makes the agent an expert witness for the court. They must understand the difference between an exclusive right to sell and a court-ordered sale, where the judge may have the final say on which offer is accepted, regardless of what the owners want. As we look at the data from the last decade, we see that homes sold by specialized divorce real estate experts tend to sell faster and for a higher percentage of the asking price than those sold by generalists. This isn't because the experts are better at marketing. It's because they are better at conflict de-escalation. By removing the emotional friction between the sellers, they allow the property to be presented in its best light, which leads to better potential outcomes for the entire family. This video is going to take you through the specific steps required to manage these transitions. We will look at how to handle the walkthrough when one party refuses to leave the house. We will examine the tax implications of the Section 121 exclusion and how it changes once a divorce decree is signed. And most importantly, we will discuss how the role of the agent has transitioned from a salesperson to a neutral third party, whose primary job is to preserve the wealth of the American family during its most vulnerable moment. This is a deep dive into the mechanics of change, the evolution of law, and the specialized skills required to navigate the next century of American real estate. To understand where we are in 2026, we have to examine the specific legal friction points that define the last century. Imagine a couple in 1952, let's call them Robert and Dorothy, living in a suburban tract home in Ohio. Under the laws of that era, the concept of a divorce real estate agent didn't exist because the property rights were often tied to the title holder, which, due to historical credit and employment trends, was predominantly the husband. If a divorce occurred, it was a matter of title, not a matter of shared equity. The real estate agent was simply a facilitator for the man who owned the deed. There was no negotiation between spouses because there was no legal parity. But as we moved into the 1970s and 1980s, the landscape shifted toward equitable distribution. This changed the fundamental DNA of the real estate transaction. Suddenly, the agent wasn't just selling a house. They were liquidating a shared retirement fund, a childhood home, and a primary savings account all at once. In the 1980s, we saw the rise of the dual-income household, which meant that for the first time in American history, both parties in a divorce often had an equal claim to the appreciation of the asset. This created a new type of logistical nightmare for real estate professionals. Historical trends from this period show a massive uptick in litigated sales. Case studies from the mid-80s reveal that without a neutral third party, houses would sit on the market for years while spouses argued over the color of the paint or the brand of the carpet, effectively using the real estate as a proxy for their emotional pain. This is where the modern divorce real estate specialist began to take shape. They realize that to sell a house in a divorce, you don't start with a lockbox, you start with a protocol. Fast forward to 2026. The complexity has scaled exponentially. We are currently navigating a market where interest rates and inventory levels have created what we call the equity trap. Imagine a modern U.S. couple. Let's call them David and Elena. They bought their home in 2021 with a mortgage rate of 2.75%. Now, in 2026, they are dissolving their marriage. The home has gained 40% in value, but the cost to borrow money for a new home has nearly tripled. This creates a psychological and financial stalemate that a standard real estate agent is simply not equipped to handle. In this environment, the divorce real estate agent must act as a data-driven strategist. They have to explain the potential outcomes of a buyout versus a sell-off, factoring in the loss of that low interest rate, which is often the most valuable invisible asset in the divorce. Let's look at the step-by-step details of how a professional divorce real estate agent handles the first 72 hours of a new case in today's market. This is the neutrality protocol, and it is the foundation of a successful sale. Step 1 is the conflict check and introduction. The agent does not take a meeting with one spouse alone. Doing so immediately compromises their neutrality and can lead to the agent being disqualified by the court. Instead, the agent sends a joint introductory email to both spouses and their respective attorneys. This email outlines that all communication will be transparent, that there will be no sidebar conversations, and that all data regarding the home's value will be shared simultaneously with all parties. This establishes the agent not as a salesperson, but as an officer of the transaction. Step 2 involves a forensic title review. In a standard sale, you might wait for the title company to do this weeks into the process. In a divorce sale in 2026, the agent does this on day 1. Why? Because of historical trends involving phantom liens. It is common in high-stress divorces for one party to have taken out a personal loan or incurred a tax lien that is attached to the property without the other party's knowledge. If an agent lists a house without knowing about a $50,000 undisclosed lien, the entire settlement can collapse at the closing table. The professional agent identifies these hurdles before the sign even goes in the yard. Step 3 is the SOP for property access. This is where most viral real estate horror stories begin. If David is still living in the house and Elena has moved out, David might have a vestigial desire to protect his territory by making the house difficult to show. The agent must implement a strict showing schedule that is agreed upon in writing and often incorporated into a court order. This schedule includes requirements for the home's show-ready condition. We have seen case studies where one spouse intentionally left the home in disarray to discourage buyers, hoping to drive the price down so they could buy out the other spouse at a discount. The specialist agent documents the condition of every room before every showing to prevent this kind of asset devaluation. Now, consider the data regarding the Section 121 tax exclusion. This is a critical piece of the deep dive that many generalist agents overlook. In the United States, an individual can exclude up to $250,000 of gain from the sale of their primary residence, and a married couple can exclude up to $500,000. However, the timing of the divorce decree relative to the date of the sale can significantly impact the tax liability of the parties. If a couple divorces before the sale and one spouse has been out of the house for more than 2 years, they could potentially lose their $250,000 exclusion. A professional divorce agent in 2026 works in tandem with the couple's tax professionals to ensure the sale is timed to maximize the potential outcomes for both parties' net proceeds. Imagine the high-stakes scenario of a refusal to sign. It is 2026 and you have a full-price offer on the table. One spouse is ready to move on, but the other, paralyzed by the fear of the unknown or a desire for leverage, refuses to sign the purchase agreement. In the past, this would lead to months of legal motions. Today, a specialized agent knows how to work with Elisa motions, where a court-appointed official can sign on behalf of the recalcitrant spouse to ensure the asset is not wasted. This level of technical knowledge is what separates a viral-level professional from someone who just puts a sign in the dirt. The role of the divorce real estate agent has evolved from being a luxury service to a standard requirement in the American legal system. As we move further into this century of change, the focus is shifting away from marketing the home and toward managing the equity. We are seeing more agents being called as expert witnesses to testify on market conditions, deferred maintenance, and the feasibility of one spouse retaining the home. They are the bridge between the emotional reality of the family and the cold, hard math of the real estate market. But even with all this preparation, There is one variable that can destroy even the most carefully planned sale: the hidden structural defects and the divorce inspection trap. Most sellers think they know their home, but in a divorce, the house itself often starts to reflect the breakdown of the relationship. Maintenance is deferred, systems are ignored, and the equity people think they have is often an illusion. How do you handle a situation where a house needs $100,000 in repairs, but neither spouse has the cash to fix it? And what happens when those repairs become a weapon in the courtroom? That is exactly what we are going to break down in the next part of this masterclass, along with the 3 deadly sins of listing a divorce property that can cost a family their entire inheritance. What is the one document that can override a spouse's refusal to sell? We will uncover that legal skeleton key in part 3. The document that serves as the ultimate legal skeleton key in a contested real estate sale is known as an order for sale, or, more specifically in many jurisdictions, an order to appoint a receiver or special master. When we look at the historical trends of the last few decades, we see a recurring pattern. One spouse wants to move forward with their life, while the other is psychologically or financially paralyzed, using the house as a tool for obstruction. In 2026, where housing inventory remains at generational lows and the stakes for every square foot of equity are higher than ever, this document has become a standard part of the high-conflict divorce toolkit. Imagine a scenario involving a couple we will call Michael and Jessica. They own a 4-bedroom home in a suburb of Charlotte, North Carolina. The year is 2026, and the property has appreciated significantly. Jessica has already moved into a rental and is ready to liquidate the asset to fund her new life. Michael, however, remains in the marital home. He refuses to sign the listing agreement, he refuses to allow photographers inside, and he ignores every email from the real estate agent. Under normal circumstances, a real estate transaction requires the voluntary signature of all title holders. But in a divorce, the court has the power to strip that veto right away. The order for sale essentially tells the world that the court is now the ultimate decision maker. It often appoints a specific real estate agent, ideally one with specialized divorce training, and grants them the authority to list the property at a price determined by a current appraisal, not by the whims of the occupants. In extreme cases, the court may appoint a receiver. This is a neutral third party who steps into the shoes of the owners. The receiver has the legal authority to sign the listing agreement, sign the purchase contract, and even sign the closing documents without Michael or Jessica ever picking up a pen. This is the nuclear option that ensures the asset is not wasted while the parties continue their legal battle. However, even with the right documents in place, many families fall into what we call the 3 deadly sins of divorce real estate. These are mistakes that, based on case studies from the 2020s, have cost American families hundreds of thousands of dollars in lost equity and unnecessary legal fees. The first deadly sin is hiring a friend of the family. This is perhaps the most common mistake in the history of the profession. Imagine if Michael suggests a real estate agent who is a close friend from his college days. Jessica, not wanting to cause further friction, agrees. This creates an immediate perception of bias. The moment the agent suggests a price reduction or shares a piece of negative feedback from a potential buyer, Jessica will likely feel that the agent is colluding with Michael to drive the price down, so he can buy her out. Historical trends show that when a biased agent is involved, the level of litigation doubles. Every email from that agent becomes an exhibit in a future court hearing. A professional divorce real estate agent in 2026 must be a stranger to both parties. Their value lies in their absolute neutrality. They are the only person in the entire transaction who does not have an emotional stake in the past, only a professional stake in the future of the equity. The second deadly sin is the price anchor trap. In 2026, we are seeing a phenomenon where one spouse insists on listing the home for an astronomically high price, well above the market data. To the outside world, it looks like they are being ambitious. In reality, it is a stalling tactic. If the house is priced 20% above market value, it will sit on the market indefinitely. This allows the occupying spouse to remain in the home, often at the expense of the marital estate, while the other spouse is stuck paying for a separate residence. A specialized agent counters this by using what we call a market absorption analysis. They don't just show what homes sold for. They show how many buyers are currently looking in that specific price bracket and how long it takes for a home to be absorbed by the market. By presenting this data to both attorneys, the agent can show that an unrealistic price is a form of waste of the marital asset, which can lead to the court stepping in with that aforementioned order for sale. The third deadly sin, and perhaps the most destructive in today's market, is the weaponization of repairs. This leads us directly into the deep dive of deferred maintenance. In a standard marriage, a leaky faucet or a cracked roof tile is a weekend project. In a divorce in 2026, it is a strategic maneuver. We have seen case studies where an occupying spouse intentionally stops all maintenance on a property. They might stop servicing the HVAC system or ignore a minor plumbing leak in the basement. Their goal is to let the house deteriorate just enough that a standard buyer will be scared off, or an inspector will find so many issues that the value plummets. Why would they do this? Frequently, it is because they intend to buy out the other spouse's interest. If they can convince a court-appointed appraiser that the house needs $100,000 in work, they can effectively lower the buyout price. The professional divorce real estate agent prevents this by conducting a pre-listing inspection. This is a comprehensive third-party report that is delivered to both spouses and their attorneys before the house even hits the market. It creates a frozen-in-time snapshot of the home's condition. If the home's condition worsens after that report, the agent has the documentation needed to show the court that the occupying spouse is committing waste, which can result in the repair costs being deducted solely from that spouse's share of the proceeds. In 2026, the financial math of these repairs is further complicated by the cost of labor and materials. A roof that costs $15,000 to replace in 2019 might cost $35,000 today. If the marital estate is cash poor, which is common when legal fees are mounting, the agent must find creative solutions. This involves the use of escrow holdbacks or contractor liens. In an escrow holdback, a portion of the sale proceeds is kept by the title company to pay for repairs that will be completed after the closing. This allows the house to sell even if it isn't in perfect condition, ensuring the couple can move on without needing to find $35,000 in cash up front. As we navigate this century of change, the role of the agent is becoming increasingly technical. They must understand the difference between a repair and an improvement in the eyes of the IRS and the local courts. They must be able to explain to a judge why a $10,000 investment in staging and minor cosmetics will result in a $50,000 increase in the final sale price, thereby benefiting both Michael and Jessica. This is not about selling a kitchen. It is about maximizing a balance sheet under extreme emotional duress. But what happens when the math doesn't add up? What if the equity everyone is fighting over doesn't actually exist? Or worse, what if there is a secret mountain of debt hidden within the walls of the home? There is a specific type of audit that every divorce real estate agent must perform that goes far beyond a standard title search. It involves tracing the path of the dollar, from the day the house was bought to the day the divorce was filed. In the next part of this deep dive, we are going to explore the world of hidden equity and the forensic real estate audit. We will look at how to find money that both spouses have forgotten about, and the one question an agent can ask that often reveals a secret second mortgage. We will also examine the move-out strategy, a step-by-step guide on how to transition a high-conflict occupant out of a home without involving the sheriff. If you think you know how a house is sold, wait until you see how it's done when the owners are at war. That legal skeleton key was just the beginning. The real secrets are buried in the closing disclosure. The real secrets are buried in the closing disclosure. And in 2026, those secrets have the power to stop a multi-million-dollar transaction dead in its tracks. To understand the depth of this, we must look at the forensic real estate audit. In a traditional sale, an agent looks at the current mortgage balance provided by the seller and moves on. In a divorce masterclass, that is considered professional negligence. Historically, we have seen a rise in what is known as silent liens. These are encumbrances that one spouse may have placed on the property without the full realization or consent of the other, or debts that have attached to the property by operation of law. Imagine a couple in Phoenix, Arizona, whom we will call Sarah and Mark. They are selling their home in 2026 after 10 years of marriage. Sarah believes the home has $400,000 in equity. However, when a specialized divorce real estate agent performs a forensic audit of the title and the path of the dollar, they discover a $75,000 HELOC draw that Mark took out 3 years prior to consolidate his personal business debts. Because Arizona is a community property state, that debt might be secured by the house, but the legal question of who is responsible for that $75,000 becomes a central theme of the divorce. If the agent isn't looking for this on day one, the discovery at the closing table creates a catastrophic emotional and legal explosion that can lead to the buyer walking away, and the sellers facing a lawsuit for breach of contract. The forensic audit begins with a tracing analysis. In 2026, We are seeing a massive influx of cases involving separate property contributions. Between 2020 and 2023, record numbers of American buyers used inheritances or family gifts to secure down payments in a hyper-competitive market. If Sarah used $100,000 from her late grandmother's estate to buy the house with Mark, that money is often considered her separate property, provided it wasn't transmuted into community property. A specialized agent doesn't just ask for the mortgage statement. They ask for the original closing disclosure from the date of purchase. They trace the source of every dollar. Why? Because the potential outcome of the sale, the net check, must be calculated with surgical precision to avoid a trial. In California and several other states, this is often referred to as a Moore-Marsden calculation. This is a complex formula used to determine the community's interest in a property that was owned by one spouse before the marriage, but was paid down using community funds during the marriage. As an agent in 2026, you must understand that the house isn't just a building, it is a mathematical equation. You are looking for the fair market value at the date of marriage, the paydown of the principal during the marriage, and the capital appreciation during the marriage. If an agent cannot explain these concepts to a frustrated seller, they lose all credibility and the ability to manage the transaction. Beyond the math, we have to address the most volatile part of the process, the move-out strategy. In many high-conflict divorces, the person living in the house has zero incentive to cooperate. If Mark is living in the Phoenix home and knows that once the house sells, he has to move into a smaller apartment and pay a higher interest rate, he is incentivized to sabotage the sale. This is what we call occupant paralysis. The step-by-step detail for a professional move-out strategy involves more than just a polite request. It involves the three-phase de-escalation protocol. Phase 1 is the incentive alignment. In 2026, we frequently use settlement incentives that are written into the listing agreement. For example, the parties might agree that if the house is vacated and professionally cleaned by a certain date, the occupying spouse receives a slightly higher percentage of the initial disbursement to cover moving costs. This reframes the move-out not as an eviction, but as a financial transaction. Historical trends show that when an occupant feels they are being paid to leave rather than being forced out, the likelihood of property damage decreases by nearly 60%. Phase 2 is the third-party logistics management. A professional divorce real estate agent should have a vetted list of movers, cleaners, and organizers who are trained in high-conflict situations. The agent coordinates these services so the spouses don't have to speak to each other. By taking the logistics off the couple's plate, you remove the friction points where arguments usually happen. Imagine if Mark doesn't have to argue with Sarah about which boxes are his because a neutral professional organizer, guided by a court-approved property list, has already sorted them. Phase 3 is the security and inspection pivot. The moment the occupant moves out, the agent must be prepared to change the locks and install a high-tech security system with the consent of both parties or a court order. This is not about locking someone out, it is about preserving the asset. In 2026, with the rise of squatting and spite re-entry, securing the property is a fiduciary duty. Case studies show that vacant divorce properties are at a higher risk for vandalism, often from one of the owners themselves. A specialized agent documents the condition of the home with a 3D Matterport scan the hour the occupant leaves. This prevents, he said, she said, disputes about the condition of the property at the time of vacancy. Let's talk about the data regarding market stigma. A house that is known to be a divorce sale can often attract bottom-feeder investors who submit lowball offers, assuming the sellers are desperate. A masterclass-level agent knows how to protect the sellers from this stigma. They do this by controlling the narrative. The agent never discloses the reason for the sale to buyers or their agents. They don't say the owners are divorcing. They say the owners are relocating. They ensure the house doesn't look like a war zone. If there are half-packed boxes and 2 separate beds in the master bedroom, the agent insists on professional staging to make the home look like a unified, happy residence. This isn't deceptive. It is a strategic move to maximize the potential outcome for the family's equity. We also need to discuss the closing disclosure audit for junk fees and liens. In 2026, we are seeing an increase in zombie debt, old credit card judgments or medical bills from a decade ago that suddenly attach to a home's title when it goes up for sale. In a divorce, these debts can be a landmine. If Mark had a credit card debt from before the marriage, and that creditor placed a lien on the house, is Sarah responsible for paying half of it out of her equity? The agent must coordinate with the title officer to identify these liens early, so the attorneys can argue over who pays them before the closing date. This brings us to a critical realization. The modern divorce real estate agent is effectively a transaction referee. You are standing in the middle of a storm, holding a clipboard and a calculator, ensuring that neither side trips the other on the way to the finish line. Every document, from the lead-based paint disclosure to the final escrow instructions, is a potential weapon. Your job is to disarm those weapons through transparency and data. But what happens when the house finally sells, the movers are gone, and the money is sitting in escrow? This is where the final and often most dangerous stage begins. Many people assume the agent's job is over when the keys are handed over. But in a divorce, the disbursement phase is where the most significant legal errors occur. If the money is sent to the wrong account, or if the tax withholding isn't handled correctly for a non-resident spouse, the agent can be held liable for years to come. In the next part of this deep dive, we are going to look at the war of the wires. We will explore how to manage the disbursement of funds when the parties cannot agree on the split, and the escrow freeze that can happen when a last-minute restraining order hits the title company. We will also examine the growing trend of post-closing litigation and how an agent can divorce-proof their file to ensure they are never dragged back into court. How do you handle a $500,000 check when two people are fighting over the last 5 cents? We are opening that vault in Part 5. The vault of a real estate transaction is the escrow account, and in 2026, the transition of funds from that account to the parties involved is where the most intense conflict occurs. To understand the war of the wires, we must first look at the historical trends of how funds have been disbursed in the United States over the last century. In the mid-1900s, a simple joint check was often issued to Mr. and Mrs. Smith. Today, that is a recipe for a legal disaster. In a modern divorce masterclass, we recognize that the moment the buyer's funds hit the escrow account, those dollars are no longer just currency. They are the final pieces of a puzzle that two sets of attorneys, a judge, and two emotional spouses are trying to solve simultaneously. Imagine a case study involving a couple in Austin, Texas, whom we will call Amanda and Chris. They are closing on the sale of their marital home in May 2026. The net proceeds after the mortgage payoff and closing costs are exactly $542,000. Under a standard listing agreement, the escrow officer would typically split the check 50/50. However, in this scenario, Chris's attorney has filed a lease pendens, a notice of pending litigation, that effectively places financial handcuffs on the property's equity. Chris claims that Amanda used community funds to pay for a vacation with a third party, and he wants a $15,000 reimbursement from her share of the home equity. Amanda counters that Chris has failed to pay the agreed-upon temporary support for 3 months, totaling $12,000, and she wants that deducted from his share. This $27,000 dispute is now standing in the way of over $500,000. In 2026, a specialized divorce real estate agent handles this through the implementation of a joint escrow instruction or a stipulation and order. The agent coordinates with both legal teams to create a step-by-step disbursement protocol. Instead of the money sitting in an interest-bearing account for months while the parties argue, the agent suggests a partial release of funds. This allows for the undisputed $515,000 to be disbursed, $257,500 to each party's respective attorney trust account, while the contested $27,000 remains in the escrow vault. This keeps the parties from defaulting on their new living arrangements, while preserving the court's ability to distribute the remaining funds once a final judgment is reached. The technical complexity of this process in 2026 cannot be overstated, particularly regarding the rise of wire fraud. Historical trends show that real estate transactions are the primary target for sophisticated phishing attacks. In a divorce where communication between the sellers is already fractured, the risk is magnified. A professional agent ensures that the escrow officer uses a voice verification protocol. This means that before any wire is sent, the officer must speak to each spouse and their attorney on a recorded line to verify the routing and account numbers. We have seen case studies where one spouse attempted to divert the other's funds by sending a fraudulent email, appearing to be from the other spouse's attorney. The divorce real estate specialist is the gatekeeper who ensures these protocols are followed to the letter, protecting the family's wealth from external predators as well as internal conflict. We also have to dive deep into the mechanics of the Qualified Domestic Relations Order, or QDRO, and how it intersects with real estate. While QDROs are typically associated with retirement accounts in 2026, we see them being used more frequently to bridge the gap in real estate equity. For example, if Amanda wants to keep the house but cannot afford to buy Chris out with cash, the parties might agree to a trade-off where Chris receives a larger portion of Amanda's 401k in exchange for her retaining 100% of the home's equity. The real estate agent must be able to read a preliminary settlement agreement to understand if the house is actually going to be sold, or if the listing is merely a stalking horse meant to establish a value for a buyout. If the agent doesn't understand this, they might spend thousands of dollars in marketing for a property that will never actually transfer to a third-party buyer. Regarding the tax implications, we must look at the Section 121 exclusion with surgical precision. In 2026, with property values in many U.S. metros reaching all-time highs, the $250,000 individual capital gains exclusion is often insufficient. If the house has $800,000 in gain, and the couple sells the home while they are still legally married, they can potentially utilize the full $500,000 exclusion. However, if they wait until the divorce is final to close the sale, they are now two single filers. Each can only exclude $250,000, meaning $300,000 of the gain could be subject to capital gains tax. A specialized agent doesn't just look at the calendar, they look at the tax code. They work with the couple's CPA to determine if the potential outcome of an earlier closing date outweighs the emotional desire to wait until the legal decree is signed. Furthermore, we must address state-specific withholding laws, such as California's Form 593 or similar statutes in other jurisdictions. When a property is sold in a divorce, the state often requires a percentage of the gross sales price to be withheld for taxes unless an exemption applies. If one spouse is moving out of state, the withholding requirements change. The agent must ensure that the escrow disclosure reflects these withholdings accurately. If Chris is moving to Florida and Amanda is staying in California, their tax liabilities on the sale are vastly different. If the agent allows a 50-50 split of the net check without accounting for the withholding, one spouse effectively pays the other's tax bill at the closing table. This leads to the concept of the divorce-proof file. In 2026, the statute of limitations for real estate-related litigation can extend for years. A professional agent maintains a comprehensive digital vault of every interaction. This includes the market absorption analysis used to set the price, the records of every offer received, and most importantly, the signatures of both parties on every addendum. We have seen historical trends where a spouse, 5 years after the divorce, sues their former real estate agent claiming they weren't informed of a higher offer. The specialist agent prevents this by using a double-blind communication log. This is a system where every piece of information sent to one spouse is automatically timestamped and sent to the other spouse and both attorneys. This radical transparency is the only way to avoid being dragged into post-closing litigation. The final stage of this masterclass part involves the post-closing audit. Once the wires have cleared and the house is recorded in the new buyer's name, the agent's job is still not quite finished. They must provide a final accounting to the attorneys. This is a line-by-line breakdown of every penny spent during the listing period, from the staging costs to the repair invoices. In a high-conflict divorce, if the agent paid a plumber $500 out of the escrow funds, they must have a receipt and written approval from both spouses. Without this level of step-by-step detail, that $500 can become the subject of a 2-hour deposition. As we move forward in this century of change, the divorce real estate agent is no longer just a person who sells houses. They are a forensic wealth manager. They are the person who ensures that the $30 trillion in American household equity isn't vaporized by poor planning, emotional reactivity, or tax ignorance. But even with all these financial safeguards, there is one variable that can circumvent every court order and every escrow instruction. It is the invisible hand of the family trust. What happens when the house isn't owned by the couple at all, but by a trust established by a grandparent who doesn't want the house to be sold? Or what happens when a secret premarital agreement surfaced at the 11th hour that claims all the appreciation in the home is separate property? We are entering the most complex legal territory yet. In the next part of this deep dive, we are exploring the intergenerational trap and the hidden world of trust-owned real estate in divorce. We will reveal the one clause in a trust document that can stop a sale even if a judge orders it. That complexity is waiting for us in Part 6. The complexity of the American real estate landscape in 2026 has reached a tipping point, largely due to the great wealth transfer that economists have been predicting for decades. As trillions of dollars migrate from the silent generation and baby boomers to their heirs, the marital home is frequently no longer a simple asset owned by two individuals. Instead, It is often entangled in the sophisticated web of family trusts. This brings us to the intergenerational trap. To navigate this, the modern divorce real estate agent must understand that the legal owner of the property is often an entity, not the people living inside the house. Imagine a couple in their early 40s, let's call them Robert and Linda, living in a colonial-style home in a high-end suburb of Northern Virginia. They have been married for 12 years, raised 2 children in this house, and treated it as their primary residence. However, the property was purchased using a significant down payment from Robert's family trust, and the title is held in the name of the Robert Sr. Legacy Trust. As they enter the divorce process in 2026, Linda assumes she is entitled to half of the $3 million in equity that has accumulated over the last decade. Robert, however, points to the trust document. This is where the world of divorce real estate turns from a sales job into a high-stakes forensic investigation. The one clause in a trust document that can stop a sale even if a family court judge orders. It is the spendthrift provision coupled with absolute trustee discretion. Historically, these clauses were designed to protect trust assets from the creditors of a beneficiary. In the eyes of many state laws, a divorcing spouse seeking a property division is treated as a creditor. If the trust is an irrevocable third-party trust, meaning it was set up by someone other than Robert for Robert's benefit, the family court may find that it has zero jurisdiction to order the sale of the home. The house isn't Robert's to sell, it belongs to the trust. Even if a judge is sympathetic to Linda, they cannot easily order a third-party trustee to liquidate an asset they don't legally control. For a real estate agent, this creates a massive roadblock. If you are hired by Linda's attorney to list the home, but the trustee refuses to sign the listing agreement, you are at a dead end. This is why the step-by-step audit of a trust-owned property is the most critical skill for an agent in 2026. Step 1 is the verification of the certification of trust. An agent must never rely on the word of the spouses. You must demand the formal abstract of the trust, which identifies the current trustees and their specific powers. In our case study, if Robert's sister is the trustee, and she has the power to withhold the sale of the asset to preserve it for the remainder man, the children, the real estate agent must pivot. You are no longer negotiating with a husband and wife. You are negotiating with a fiduciary whose primary duty is to the trust's long-term health, not the dissolution of a marriage. Step 2 involves the analysis of transmutation. This is where the agent works with forensic accountants to determine if the trust's separate property status was compromised. Did Robert and Linda use community income to pay the mortgage? Did they use shared funds for a $200,000 kitchen remodel? If community funds were used to improve or maintain a trust asset, the community may have developed a more Marsden interest in the property. Historical trends in 2026 show that courts are increasingly willing to grant a spouse a monetary credit for their contribution to a trust asset, even if they cannot force the sale of the asset itself. The agent must provide a dual valuation. What is the home worth today? And what was it worth before the community-funded improvements? This data becomes the leverage used to settle the case. Step 3 is the partition action overlay. If the trust owns 50% of the home and the couple owns the other 50%. A common scenario in 2026 as families help their children buy into expensive markets, the agent must understand the mechanics of a partition sale. This is a separate civil action that forces a sale of a property when co-owners cannot agree. A specialized divorce agent knows how to use the threat of a partition action to bring a reluctant trustee to the table. A partition sale often results in a lower price due to the legal costs and the nature of the auction, which is a negative potential outcome for everyone involved. By highlighting this risk, the agent can often facilitate a voluntary sale at fair market value. The data regarding trust-owned real estate in the U.S. is staggering. In 2026, it is estimated that nearly 25% of homes in the top 10% of market value are held in some form of trust or LLC. This shift has necessitated a change in how agents handle the property disclosure statement. When a trust sells a property, the trustee often has never lived in the home. They may be legally exempt from many of the standard disclosure requirements because they lack personal knowledge of the property's condition. This creates a buyer's risk that can drive down the price. A professional divorce agent counters this by performing a voluntary comprehensive disclosure package. They have the occupants, Robert and Linda, fill out the disclosures even if they aren't the legal sellers. This transparency protects the trust from future litigation and ensures the highest possible price is achieved. Imagine the scenario of the stepped-up basis trap. If the trust property is sold as part of a divorce, The parties must consider the tax consequences. If the house has been in a family trust for 30 years, the capital gains could be massive. A specialized agent in 2026 must be able to discuss the potential outcomes of a 1031 exchange or the implications of the trust tax bracket versus the individual's tax bracket. While the agent does not give tax advice, they must be the one to flag the issue so the attorneys don't overlook it in the rush to settle. Furthermore, we must address the right of first refusal often found in family trusts. In 2026, many legacy trusts include a clause that says if a property is to be sold, other family members or the trust itself has the right to buy it at the appraised value before it hits the open market. This can be a devastating blow to a spouse who was hoping for a bidding war on the MLS to maximize their payout. The real estate agent's role here is to ensure the appraisal used for the right of first refusal is accurate and reflects the current, hyperlocal market conditions. They must advocate for a neutral, court-approved appraiser to prevent a family discount from eroding the marital equity. The evolution of the divorce real estate agent in this century is a move toward becoming a legal real estate hybrid. You are navigating the intersection of the family code, the probate code, and the civil code. You are managing the expectations of a spouse who feels entitled to an asset, and a trustee who feels a duty to protect it from that very person. It is a game of chess played with multi-million-dollar pieces. But even if you navigate the trust, the title, and the trustees, there is one final battlefield that destroys more deals in 2026 than anything else: the appraisal. In a market where prices are volatile and interest rates are shifting, the value of a home is no longer a fixed point. It is a range of opinions. And when those opinions differ by hundreds of thousands of dollars, the war moves from the living room to the courtroom. In the next part of this masterclass, we are going to dive into the appraisal war. We will look at how to spot a low-ball appraisal meant to facilitate a cheap buyout, and how to challenge a high-ball appraisal meant to stall a sale. We will examine the step-by-step process of an appraisal rebuttal, and the specific data points that can flip a judge's opinion in minutes. What happens when two professional appraisers look at the same house and come up with two different realities? We are deconstructing the science of valuation in Part 7. The appraisal is the heart of the equity battle, because it is the only document that attempts to turn a subjective emotional attachment into a cold, hard number. In the United States in 2026, the volatility of the housing market has made the standard appraisal a lightning rod for litigation. When two professional appraisers look at the same four-bedroom home in a suburb like Naperville, Illinois, and come up with values that differ by $150,000, we aren't looking at a mistake. We are looking at a difference in philosophy and often a difference in the instructions they were subtly given by the parties who hired them. This is the deconstruction of the science of valuation, where the real estate agent must step in as the forensic auditor to ensure the potential outcomes for the family are based on reality rather than tactical manipulation. Imagine a couple we will call James and Olivia. It is June 2026. They bought their home in 2018 for $450,000. Today, James wants to stay in the house. To do that, he needs to buy out Olivia's 50% share of the equity. Naturally, James is incentivized to have the house appraised as low as possible to reduce his payout. Olivia, who needs her share of the equity to afford a new place in a market with 8% interest rates, wants the highest valuation possible. James hires an appraiser who specializes in estate work. This appraiser finds 3 comparable sales, what we call comps, that are located near a busy intersection, have original 1990s kitchens, and closed as distressed sales. The resulting value is $625,000. Olivia is outraged. She knows the house down the street sold for $780,000. This is where the appraisal war begins. The first step in deconstructing this is the forensic review of the Uniform Residential Appraisal Report, or the URAR. A professional divorce real estate agent doesn't just look at the final number on page 2. They look at the adjustments on the grid. In 2026, we see a massive trend in what we call selection bias in comps. James's appraiser deliberately chose comps that were inferior in condition but similar in size. To counter this, the agent must perform a line-by-line audit of the adjustments. For example, if the appraiser only gave a $10,000 adjustment for a finished basement that cost $80,000 to build in 2024, the agent highlights this as an underadjustment. Historical trends in the 2020s show that the cost of labor and materials has surged, yet many appraisers are still using adjustment figures from 2015. A professional agent brings the current 2026 construction cost data to the table to prove that the adjustment should be closer to $40,000. Now, consider the highball strategy. Olivia hires her own appraiser who uses comps from a superior school district half a mile away and includes a property that was a custom build with high-end smart home integration. Her appraiser brings back a value of $810,000. Now the judge has two reports, one for $625,000 and one for $810,000. This is an $185,000 gap. In the eyes of the court, this creates a stalemate that can freeze the divorce for months. The specialized agent's job is to create an appraisal rebuttal that is so data-dense it forces a settlement. The step-by-step process of an appraisal rebuttal in 2026 involves three phases. Phase 1 is the proximity and recency audit. In a fast-moving market, a comp that is 6 months old is ancient history. The agent pulls the most recent pending sales, houses that are under contract but haven't closed yet. While appraisers usually only use closed sales, a judge in 2026 is often interested in current market sentiment. If 3 houses in the neighborhood went under contract in the last 14 days at prices above $750,000, it proves that James's $625,000 appraisal is historically irrelevant. Phase 2 is the quality of finish and amenity mapping. This is where the agent's knowledge of the specific home becomes a weapon. In 2026, specific upgrades have high divorce value. For instance, a home with a fully integrated Tesla Powerwall and solar array or a high-efficiency geothermal HVAC system carries a premium that generalist appraisers often miss. The agent creates a feature sheet that calculates the specific ROI of these items based on 2026 energy costs. By showing that the home's utility bills are $300 lower per month than the comps James used, the agent justifies a higher energy-efficient adjustment on the appraisal grid. Phase 3 is the expert witness testimony. If the case goes to a hearing, the real estate agent is often called to testify. They don't just say the house is worth X. They explain the absorption rate. They tell the judge, if we put this house on the market today for $750,000, based on current inventory levels in this zip code, it would be under contract in 11 days. This real-world market data often carries more weight with a judge than a sterile appraisal report that was written by someone who spent 20 minutes in the house. There is also the phenomenon of the 706 expert. In high-conflict cases, a judge may lose patience with the competing appraisals and appoint their own neutral appraiser under Evidence Code 706. While this is meant to be the gold standard, a professional agent knows that even neutral appraisers need to be educated. The agent meets the 706 appraiser at the property and provides them with a neutral disclosure packet. This packet contains the same data given to both spouses: the inspection reports, the list of upgrades, and a curated list of comps that represent the middle ground. By being the most prepared person in the room, the agent often guides the neutral appraiser toward a valuation that is fair, which facilitates a buyout or a sale without further litigation. In the 2026 environment, we must also account for the impact of interest rates on valuation. This is a critical deep dive. When rates are high, as they are in 2026, the pool of buyers for an $800,000 home shrinks. An appraiser might not account for the fact that a home in this price bracket now requires a household income that only the top 5% of the local population possesses. A specialized divorce agent uses mortgage feasibility data to show the court that while the house might have a theoretical value of $800,000, its liquid value, what someone can actually afford to pay today, might be lower. This protects a spouse who is being forced to sell from being held to an unrealistic price anchor that results in the house sitting on the market until it forecloses. Case studies from 2025 and 2026 show that the appraisal gap is one of the leading causes of post-settlement regret. This occurs when a spouse buys out the other based on an appraisal, only to find 6 months later that they cannot refinance because the value has shifted or the initial report was flawed. The real estate agent prevents this by insisting on a desktop underwriter review of the appraisal before the divorce decree is signed. This ensures that the number being used to split the family's largest asset is a number a bank will actually lend against. But what happens when the number is agreed upon, the judge is happy, and the parties are ready to move, but the bank says no? In 2026, we are facing a crisis that didn't exist in the same way 10 years ago. It's the assumption trap. With so many couples holding 3% mortgages and facing a 7% market, the ability for one spouse to assume the existing loan is the difference between a successful buyout and a forced, high-tax sale. but the banks have made this process a nightmare. In the next part of this masterclass, we are diving into the hidden world of mortgage assumptions and the release of liability war. We will explore why 90% of assumption applications are denied and the specific secret clauses in modern loan servicing agreements that can actually allow a spouse to keep their low rate even after a divorce. We will also examine the internal refinance and the role of the divorce lending specialist. How do you keep a 3% interest rate when the bank wants to force you into a 7% one? We are breaking the bank in Part 8. The banking standoff of 2026 has created an environment where the mortgage is often more valuable than the house itself. In a standard real estate market, a mortgage is simply a debt to be cleared upon sale. But in a divorce masterclass, we recognize that a 3% interest rate is an intangible asset that can be worth hundreds of thousands of dollars over the life of the loan. This brings us to the breaking point of the modern divorce settlement: the struggle to keep the rate while removing the spouse. This is the world of the mortgage assumption and the release of liability. Imagine a couple in Denver, Colorado, whom we will call Brian and Sophia. They purchased their home in late 2021 with a $450,000 mortgage at a fixed rate of 2.85%. It is now 2026, and the prevailing market rates for a 30-year fixed mortgage are hovering around 7.2%. Sophia has been awarded the home in the divorce decree, and she has enough income to cover the monthly payments. However, Brian's name is still on the promissory note. If Sophia simply keeps making payments, Brian remains legally responsible for the debt. If Sophia misses a payment, Brian's credit score, which he needs to buy his own residence, will plummet. Historically, the solution was a simple refinance. Sophia would take out a new loan in her name only and pay off the old one. But in 2026, that math is devastating. A refinance from 2.85% to 7.2% would increase Sophia's monthly payment by nearly $1,200. For many American families, that is the difference between keeping the home and being forced into the rental market. This is where the divorce real estate agent must work with a certified divorce lending professional to navigate the mortgage assumption process. A mortgage assumption is a transaction where one person takes over the legal responsibility for an existing mortgage. In 2026, there are two primary types of assumptions: qualified assumptions and simple assumptions. A simple assumption is a transfer of the property title where the new owner takes over payments, but the original borrower remains liable to the bank. In a divorce, this is almost always a catastrophic mistake. Brian would be insane to agree to this because he would have no control over the property but all the risk of the debt. The goal is always a qualified assumption with a release of liability. In this scenario, the lender performs a full credit and income underwrite on Sophia. If she qualifies, the bank removes Brian's name from the loan and formally releases him from any future obligation. Here is the step-by-step detail of why this process currently has a rejection rate of nearly 90% in the United States, and how the professional agent overcomes those odds. The first hurdle is loan type eligibility. Historically, FHA, VA, and USDA loans are legally required to be assumable. If Brian and Sophia have a VA loan, the bank generally cannot refuse a qualified assumption. However, most conventional loans, those sold to Fannie Mae or Freddie Mac, contain a due on sale clause. This clause gives the bank the right to demand the full balance of the loan if the title is transferred. However, a specialized agent knows the Garn-St. Germain Depository Institutions Act of 1982. This federal law provides a critical protection. Lenders are strictly prohibited from enforcing a due on sale clause when the transfer is the result of a divorce decree or legal separation agreement, provided the transferee is a spouse and occupies the property. This is the legal shield that allows Sophia to keep her 2.85% rate. But even with this shield, the bank will often fight the process. Why? Because the bank would much rather Sophia refinance at 7.2%. To the bank, a 2.85% loan in a 7% market is a losing asset. The second hurdle is income verification and the 6-month rule. This is where most assumptions fail. If Sophia is using alimony or child support to qualify for the loan on her own, most lenders require a historical trend of receipt. In 2026, the standard guideline is that support income must have been received consistently for at least 6 months and must be scheduled to continue for at least 3 years. If Sophia's divorce was just finalized yesterday, she cannot use that support income to qualify for the assumption today. The professional agent prevents this failure by structuring the temporary orders months in advance, ensuring that by the time the final decree is signed, Sophia already has the 6-month track record required by the lender. The third hurdle is the release of liability standoff. Many banks will tell a divorcing couple that they allow the assumption, but will not grant a formal release of liability. This is a trap. Without a written release of liability from the lender, Brian's debt-to-income ratio will still include that $450,000 mortgage, even if the court says it is Sophia's responsibility. In 2026, this effectively prevents Brian from ever qualifying for a new home of his own. A specialized agent ensures that the divorce decree is contingent upon the bank providing a formal release, or they pivot to an internal refinance. An internal refinance or a modification of note is a less common but highly effective strategy where the lender agrees to remove a spouse and keep the interest rate the same, often in exchange for a small fee or a very slight rate adjustment, perhaps moving it from 2.85% to 3.25%. While this is higher than the original rate, it is a potential outcome that is vastly superior to the 7.2% market rate. This requires the agent to bypass the local branch manager and get in touch with the bank's executive escalation team or the divorce servicing department. Let's look at the ALTI of partition lien, a tool frequently used in states like Texas but applicable in concept elsewhere. Imagine Sophia has the income to keep the house, but she doesn't have the cash to buy out Brian's $200,000 of equity. In 2026, she can use an ALTI lien to roll that equity buyout into the existing mortgage. This is a specialized legal instrument that allows the house to be treated as a single asset for the purpose of the buyout, preventing the IRS from seeing the transaction as a sale that would trigger taxes, and allowing the lender to treat the buyout as a rate and term refinance rather than a cash-out refinance, which usually carries much higher interest rates. Case studies from 2026 show that the success of these banking maneuvers depends entirely on the timing of the quitclaim deed. A common mistake made by generalist agents is having the departing spouse sign a quitclaim deed early in the process. If Brian signs the deed before the bank has approved the assumption, he has given up his ownership of the asset while still being 100% responsible for the debt. This is a position of extreme vulnerability. The professional agent manages the escrow of the deed, ensuring it is only recorded the moment the bank's release of liability is signed and delivered. The role of the divorce real estate agent in 2026 has become that of a mortgage architect. You are building a financial bridge between two lives, using federal law, banking regulations, and specific loan servicing guidelines. You are fighting a multi-billion-dollar banking industry that wants to claw back low-interest loans, and you are doing it one household at a time. But even if you win the war with the bank and the mortgage is secured, there is a hidden predator waiting at the finish line. It is a ghost from the past that lives in the county records. It is the title insurance nightmare. In a century of change, the way we track ownership has become more digital, but the way we track claims against that ownership has become more chaotic. What happens when a lien from a previous owner, or a secret debt from a spouse's past life, suddenly appears on the title report 3 days before closing? In the next part of this masterclass, we are exploring the title minefield. We will look at the rise of zombie liens and child support judgments that can swallow an entire family's equity. We will reveal the one title endorsement that every divorce real estate agent must demand to protect their clients from future litigation. The bank was just the first gatekeeper. The title officer is the final boss. We are entering the minefield in Part 9. The title officer is indeed the final boss of the real estate transaction, and in 2026, the digital footprint of American property has made the title minefield more explosive than ever before. When a couple enters a divorce, they often focus on the bank and the appraisal, but the preliminary title report is the true financial autopsy of the marriage. It is a document that reveals every secret, every mistake, and every forgotten debt that has attached itself to the family's largest asset over the last century. Historically, title searches involved human beings scouring physical ledgers in dusty county offices. Today, in 2026, AI-driven title engines aggregate data from thousands of sources in seconds, pulling up records that would have remained hidden a decade ago. This technological evolution has led to the rise of what we call zombie liens, and the sudden reappearance of clouds on the title that can vaporize a deal in 48 hours. To understand the stakes, imagine a case study involving a couple in Orlando, Florida, whom we will call Alex and Taylor. They are selling their marital home in July 2026. The house is under contract for $850,000, and the couple believes they are walking away with $300,000 in net equity. However, when the preliminary title report is generated, a $65,000 judgment appears. It is a debt from a credit card that Alex had in 2012, long before he even met Taylor. In many states, a judgment against one spouse automatically attaches to any real estate they own, even if the other spouse had no knowledge of the debt. Because Florida is a state with strong homestead protections, Alex assumed the debt couldn't touch the house. But the title officer sees it differently. To provide the buyer with a clean title insurance policy, that $65,000 judgment must be satisfied at the closing table. This discovery doesn't just reduce the equity. It ignites a new legal war between Alex and Taylor over who is responsible for paying a debt that Taylor didn't even know existed. This is the reality of the title minefield in 2026. A specialized divorce real estate agent doesn't wait for the title company to find these issues. They order a pre-listing title search the moment the listing agreement is signed. This is a proactive step-by-step audit of the Schedule B exceptions. Schedule B is the part of the title report that lists everything the title insurance policy will not cover. In a divorce, this section is usually filled with landmines. The first landmine is the child support and alimony lien. In many jurisdictions, unpaid support payments automatically become a lien against any real property owned by the payer. If Taylor was previously married and owed back child support, that debt is now a senior lien on the current marital home. Historical trends show that these liens often have priority even over the primary mortgage in certain states. The real estate agent must work with the title officer to obtain a payoff demand from the state's disbursement unit. If the agent doesn't handle this with surgical precision, the sale can be blocked by the state, or worse, the funds can be frozen in escrow for months while the government performs an audit. The second landmine is the mechanic's lien for spite repairs. We discussed the weaponization of repairs in earlier parts of this masterclass, but the title minefield is where those weapons are actually fired. Imagine Alex hires a contractor to fix the roof during the divorce, but refuses to pay the full bill because he claims the work was subpar. The contractor files a mechanic's lien against the property. Even if the lien is for a relatively small amount like $5,000, it creates a cloud on the title. In 2026, a buyer's lender will not fund a loan if there is an active mechanic's lien on the property. The professional agent must negotiate a lien release or an escrow holdback where 150% of the lien amount is kept in a separate account to satisfy the title underwriter, allowing the sale to proceed while the dispute is litigated elsewhere. The third and perhaps most complex landmine is the ghost owner or the unrecorded deed. In 2026, with more families using private lending or family-funded down payments, we see a rise in unrecorded interests. Imagine Taylor's parents provided $100,000 for the down payment back in 2018 and had Alex and Taylor sign a deed of trust that was never actually recorded at the county office. Now, seeing the marriage dissolve, the parents record that deed to ensure they get their money back before the equity is split. This is a potential outcome that can lead to allegations of fraudulent conveyance. A specialized agent performs a deep dive into the original purchase files to ensure no such ghost interests exist that could derail the closing. To protect their clients from these disasters and the inevitable post-closing litigation, the professional divorce real estate agent must demand a specific set of title endorsements. The most critical is the Alta 9, or the equivalent family law endorsement. This endorsement provides additional coverage against losses resulting from the violation of restrictive covenants or the existence of encroaching structures. But more importantly, the agent ensures that both spouses sign an affidavit of no new debts. This is a sworn statement, often required by the title company in 2026, where each spouse declares under penalty of perjury that they have not incurred any new liens or judgments since the title search was performed. If Alex secretly takes out a personal loan the week before closing, this affidavit provides Taylor with a clear legal path to hold him solely responsible for that debt. We also have to address the rise of cybersecurity title risks. In 2026, title theft and deed fraud are at an all-time high. In a high-conflict divorce, we have seen case studies where one spouse attempts to forge the other spouse's signature on a grant deed to transfer the property to a shell company or a relative. A specialized agent prevents this by using multi-factor identity verification for all signatures. They ensure the title officer uses a mobile notary, who is specifically trained to spot signs of duress or forgery in domestic dispute cases. This level of step-by-step detail is what ensures the transaction is not only successful, but legally unassailable. The historical trends of the last century have moved us from a system of trust to a system of total verification. The title officer isn't just checking names. They are checking the integrity of the entire marital history as it relates to that piece of dirt. The agent's role is to be the translator between the legal requirements of the title underwriter and the emotional volatility of the sellers. You are essentially clearing the path so the equity can flow from the house to the parties' bank accounts without being intercepted by old creditors or new mistakes. But even when the title is clear, the bank is satisfied, and the appraisal is accepted, there is one final silent hurdle that most people never see coming until it is too late. It is the moment when the sold sign goes up, the moving trucks are gone, and the parties realize that the house was the only thing still holding them together. The closing of a divorce real estate deal isn't just a financial event. It is a psychological transition that requires a masterclass in after-action management. What happens in the final 60 minutes before the wires are sent? How do you handle the key exchange when the parties refuse to be in the same zip code? And most importantly, how do you ensure that the end of the sale doesn't trigger a new round of litigation? We are entering the final chapter of this deep dive. The conclusion, the legacy, and the future of the American family home are all coming together. We are closing the file in Part 10. The final 60 minutes before the closing of a divorce real estate transaction are often the most volatile in the entire process. This is the moment when the abstract numbers on a settlement statement become an irreversible financial reality. In 2026, the speed of digital banking means that once the escrow officer initiates the wire transfers, there is no turning back. For a couple like Alex and Taylor, whom we have followed through this masterclass, this hour represents the definitive end of a shared history. The house is no longer a home. It is a dispersed set of funds. To ensure this transition does not trigger a final round of litigation, the professional divorce real estate agent must implement a strict final hour protocol. This protocol begins with the final verification of the closing disclosure. In 2026, we see a historical trend where last-minute disputes over small amounts, such as a $200 cleaning fee or a $500 repair credit, can derail a $1 million closing. The agent must have written sign-off from both Alex and Taylor on the final numbers at least 24 hours before the wires are sent. This prevents the escrow freeze, where one party calls the title company in a panic, claiming they didn't authorize a specific deduction. By the time the final hour arrives, the agent's job is to maintain a sterile communication environment. There are no negotiations left. There is only the execution of the court-approved plan. One of the most complex elements of this final phase is the key exchange. In the mid-20th century, this was often a cordial, if somber, meeting at a lawyer's office. In 2026, in a high-conflict U.S. divorce, a face-to-face meeting is a significant risk factor. The modern protocol involves a digital key handoff. Using smart lock technology, the agent ensures that Alex's access codes are deactivated the moment the deed is recorded, and Taylor's codes are wiped once she has removed the last of her belongings. The new buyer is then issued a fresh encrypted master key. This removes the possibility of spite re-entry, a scenario we have seen in numerous case studies where a former owner returns to the property after closing to remove fixtures or intentionally cause damage. Regarding the move-out itself, the agent must perform a post-move-out inspection that is as rigorous as the initial listing inspection. In 2026, we use 3D LiDAR scanning to create a digital twin of the empty house. This scan is shared immediately with both Alex, Taylor, and their respective legal teams. If Taylor moved out and left a pile of trash in the garage, the scan provides the objective evidence needed to justify a professional hauling fee, which is then deducted from her share of the proceeds before the final wire is sent. This step-by-step documentation is what prevents a spouse from being blamed for damage they didn't cause, or from getting away with waste at the 11th hour. As the wires clear, we must address the 1099-S reporting. This is a critical deep dive into the intersection of real estate and the IRS in 2026. Because the home was a marital asset, the title company must report the sale. However, the potential outcomes for Alex and Taylor's tax returns depend on how that reporting is structured. A specialized agent ensures the title officer issues two separate 1099-S forms, one for Alex and one for Taylor, reflecting their specific share of the gross proceeds. If the title company issues a single form to Alex, he may be held liable by the IRS for the entire capital gain, even if he only received half the money. This is a clerical error that can take years of audits to fix. The professional agent catches this at the closing table, ensuring the tax trail is as clean as the title. Reflecting on this century of change, we can see how the role of the American family home has evolved. In 1926, the home was often a permanent legacy, a piece of property meant to be passed down through generations. Divorce was a scandalous rarity that often resulted in the total loss of property for one party. By 1976, the home became a vehicle for middle-class wealth, and no-fault laws began the shift toward equitable division. Now, in 2026, the home is treated more like a sophisticated investment vehicle. The divorce real estate agent has evolved from a simple facilitator to a forensic equity manager. We are now seeing the rise of divorce-ready mortgages and fractional ownership agreements that are signed at the time of purchase, anticipating the potential for future dissolution. These historical trends suggest that in the coming decades, the exit strategy for a home will be as important as the purchase strategy. Imagine the future of this profession. We are already seeing AI-driven platforms that can predict the most likely settlement price of a home based on the specific judicial history of the presiding judge and the historical behavior of the attorneys involved. In the next century, the appraisal war may be replaced by decentralized, blockchain-based valuations that provide a real-time, undisputed value for every square foot of residential equity. This would remove the emotional friction of valuation, but it will never remove the need for a human referee to manage the physical transition of the property. As we close the file on this deep dive masterclass, it is important to understand the legacy of the divorce real estate agent. You are not just selling a house. You are preserving the financial foundation of two separate futures. When Alex and Taylor receive their respective wires, they aren't just getting money. They are getting the seed capital for their next chapters. The success of the agent is measured by the lack of drama. A viral success in this field is a closing where the attorneys have nothing to litigate, the judge has nothing to rule on, and the parties can move forward without the weight of unresolved property disputes. The step-by-step mastery of neutrality, forensic auditing, and technical banking knowledge is what separates the generalist from the specialist. We have explored the minefields of title, the traps of mortgage assumptions, the wars of the wires, and the psychology of the move-out. Every one of these points is a link in a chain that holds a family's wealth together during a period of maximum entropy. As you look toward 2027 and beyond, the challenges will continue to mutate. Environmental disclosures, digital asset integration, and shifting domestic partnership laws will add new layers of complexity to the divorce real estate file. But the core principle remains the same. The agent is the steward of the equity. By mastering the technical details provided in this 10-part deep dive, you are positioning yourself at the forefront of a profession that is becoming more essential to the American economy every single day. The century of change has brought us to a place where data-driven neutrality is the highest form of advocacy. This concludes our deep dive masterclass on the century of change for the divorce real estate agent. The final wire has been sent, the keys have been digitized, and the file is ready for archiving. The next time you see a for sale sign on a suburban lawn, you will see more than just a house. You will see the complex legal, financial, and historical architecture that supports the American dream, even when that dream changes shape. The future of real estate isn't just about how we live together. It's about how we fairly and efficiently move apart. The evolution of the U.S. housing market is far from over, and the next major shift involves the rise of the silver divorce and the liquidation of the largest generation's real estate holdings. How will the market absorb trillions in equity as boomers enter their final transition? We will begin exploring the mechanics of the great liquidation in our next series.